Hello everybody, welcome to iExamB's Legal Bee. This is Amrita, your law faculty at iExamB. कॉन्सेप्ट्स पढ़ाएंगे, सबको सिखाएंगे. ये कैंपेन iExamB ने शुरू किया है सारे स्टूडेंट्स के कंसेप्ट्स क्लियर करने के लिए. फॉर एनी सब्जेक्ट and also to qualify any examination, conceptual clarity is a must. So to help students worldwide with this, we have come up with this campaign. Arbitration, conciliation and mediation is the topic that I will be discussing in this video today, and with a clear demarcation of line of difference, which is very thin line of difference between all these three concepts. So once again, welcome to iExamB. Don't forget to subscribe to all our YouTube channels and stay updated with all such kind of beneficial videos. You can also write to us at hello@iexamb.com in case you have any queries, and also you can call on this number. आप iExamB की वेबसाइट पर भी विजिट कर सकते हो, that is www.iexamb.com, और सारे कोर्सेज को भी चेकआउट कर सकते हो, मॉक टेस्ट को सॉल्व कर सकते हो, and these mock tests are free. सो प्लीज़ विजिट द वेबसाइट. एंड अगर आपके कोई भी क्वेरीज हैं या सजेशंस हैं, या फिर आपको किसी कंसेप्ट पर वीडियो की ज़रूरत है, यू कैन राइट टू अस इन द कमेंट सेक्शन ऑफ दिस वीडियो एज वेल. सो लेट अस स्टार्ट. ADR. व्हाट इज दिस ADR? स्टार्टिंग विद दिस, ADR का फुल फॉर्म है ऑल्टरनेट डिस्प्यूट रेजोल्यूशन सिस्टम. So this alternate dispute resolution is actually S is for system. Alternate dispute resolution systems, ADRs. So these ADRs methods, these ADR techniques, which is commonly known as alternate dispute resolution, the word itself suggests are the out of court settlement of dispute techniques. Alternatively, you are resolving your disputes without going into the lengthy process of court, which is time consuming. And also we all know justice delayed is justice denied. So these concepts are developing and these techniques are becoming prevalent with time. So let us know what is this ADR, and we are going to discuss arbitration, mediation, conciliation, which are actually ADR techniques only. So this area of ADR is evolving day by day. For international disputes as well, and also in India it is growing day by day. It is growing at a very fast pace. सो इसके लिए जो डिफरेंट टेक्निक्स हैं, उसमें से 3 बहुत ही इंपॉर्टेंट टेक्निक्स है: आर्बिट्रेशन, कंसीलिएशन, मीडिएशन. इसके अलावा सिंपल नेगोशिएशंस को भी हम लोग ADR का पार्ट मान सकते हैं. बट अगर हम लोग लीगली देखते हैं, आर्बिट्रेशन एंड कंसीलिएशन आर कवर्ड अंडर द 1996 एक्ट, आर्बिट्रेशन एंड कंसीलिएशन. मीडिएशन जनरली आप मैट्रिमोनियल डिस्प्यूट्स में देख सकते हो. लेकिन the thing that is of our concern over here is that what is the difference between all these 3 concepts. We know that we are going to settle our disputes outside court and all these 3 concepts. But what is the difference between all these 3? That is a topic of concern, जिस पर conceptual clarity की ज़रूरत है. पहले देखते हैं arbitration. Arbitration, if you will compare, if we study in a comparative manner, arbitration is more formal as compared to conciliation. Conciliation is more formal as compared to mediation. इस तरीके से आप इसको चेकआउट कर सकते हो. कोर्ट प्रोसीजर्स की बात करें, सो ऑब्वियसली द कोर्ट प्रोसीजर्स आर द मोस्ट फॉर्मल. आर्बिट्रेशन इज लेस फॉर्मल as compared to the court procedures. Of course, the rules of evidence are relaxed in case of arbitration. Dispute is submitted to an arbitral tribunal. Arbitral tribunal consists of an arbitrator. That arbitrator can be a sole arbitrator as well. That arbitrator is voluntarily chosen by the parties themselves. So that is the reason that they don't have any right to appeal. They cannot file appeal because they have voluntarily chosen the parties. They have voluntarily entered into arbitration by an arbitration agreement, and they have resolved their dispute. Appeal can lie only in cases when there are grounds like the arbitrator has acted out of his jurisdiction. He has not acted legally. The arbitrator was not appointed properly. There are some technical difficulties. Then there are some grounds of challenge. But other than that, there is no right to appeal. Award is passed just like a judgment, we can say. Award is passed and that award is binding on the parties. This is a very formal decision which is given, and this is actually a sense of adjudication which is entered into an arbitration. Adjudication होता है का मतलब क्या है कि adjudication होता तो है but court नहीं करता है, एक arbitrator करता है. There is very less judicial intervention. Only for some interim measures, if required, court can intervene and court can make certain orders. For example, appointment of guardian. इसका एग्जाम्पल हो सकता है, कुछ इंटरिम मेजर्स है. इफ आर्बिट्रेरी ट्रिब्यूनल नहीं दे पा रहा है रिलीफ, तो पार्टीज कोर्ट को अप्रोच कर सकती है बाय एन एप्लीकेशन. इफ द कोर्ट फील्स एक्सरसाइजिंग इट्स डिस्क्रिशनरी पावर्स, कोर्ट कैन गिव सच काइंड ऑफ अ रिलीफ, बट very less judicial intervention is permitted. So this is what is the technique of arbitration. Arbitration is just like court, just the procedure is relaxed. Evidence taking rules are relaxed because evidence CPC applicable नहीं होता है. So that becomes very easy. Place of arbitration is also left on the parties. Everything is left on the parties. Language barrier is not there. So comparatively it is very लेस फॉर्मल. बट अगर आप कंसीलिएशन और मीडिएशन से देखोगे तो इट इज फॉर्मल, एंड आर्बिट्रेशन इज अ काइंड ऑफ एडजुडिकेशन बिकॉज द डिसीजन इज बीन टेकन बाय द आर्बिट्रेटर ओनली. दैट इज व्हाट इज द मेन पॉइंट ऑफ डिफरेंस. Now if we come to conciliation, we will have more conceptual clarity on the point, because in conciliation, conciliator assists the parties to a dispute. He does not make a decision for them. This is the thing that you need to understand, and इससे ही आपके सारा कंसेप्ट क्लियर हो जाएगा कि कंसीलिएटर डिसीजन नहीं लेता है, कंसीलिएटर पार्टीज को असिस्ट करता है ताकि वो एक म्यूचुअली सेटिस्फैक्ट्री अग्रीमेंट या सेटलमेंट में एंटर हो जाए. कंसीलिएटर इज एन एक्सपर्ट. Voluntarily he is being chosen by the parties. He is an impartial person. He can be more than one as well. There can be more than one conciliators also. But the procedure is very less formal and there is no kind of systematic award that is drawn up. Civic settlement agreement draw up होता है अगर conciliator के recommendations parties accept करती हैं तो. If reject करती हैं then the conciliation fails. So if the parties accept the settlement document, then it will be binding on them. It is like that. If we see, it is not a binding procedure जैसे award pass होता है, लेकिन अगर parties ने उस settlement को accept कर लिया है तो उस settlement की validity होती है. So conciliation procedure is kind of assistance to the parties, and of course the conciliator helps them in drawing up the settlement agreement, gives them recommendations. Adjudication and decision making is not with the conciliator like that in arbitration. Now let us go to mediation. Mediation को आप फैमिली मैटर्स में, मैट्रिमोनियल मैटर्स में ज़्यादातर क्यों देखते हो? क्योंकि ये बहुत ही ज़्यादा इनफॉर्मल है. यहाँ पर ज़रूरत होती है कम्युनिकेशन की. So the mediator does this job very well. Mediator, because there is no kind of technical expertise which is required in matrimonial disputes. We all know that. So any impartial person, he comes into that process. He tries to bring the parties together at one table. That is his main job, and facilitates the communication between the parties. He does not decide the dispute for them. He makes them communicate and tries to settle their disputes, but they only settle their disputes. Mediator just makes them settle their disputes. This is what is the thing. ये मीडिएशन का कंसेप्ट पहले के ज़माने में हमारे फैमिली में होता था बिकॉज जॉइंट फैमिली सिस्टम हुआ करते थे. सो द एल्डर्स ऑफ द फैमिली यूज टू डू दिस जॉब ऑफ मीडिएशन. बट नाउ डेज सिंस we don't have that much we don't have many joint families left now. This concept is day by day it is ruling out. So the families, the couple, we can say married couples, they are entering into disputes and hasty divorces have increased. So that is the reason I gave you this example of matrimonial disputes में mediation की process मैंडेटरी हो गई है अभी. कोर्ट रेफर्स द डिस्प्यूट कंपल्सरीली फॉर मीडिएशन. So the mediator tries to help them with some mutually acceptable resolution of disputes. Obviously, he suggests them, and the mediation ultimate control of the outcome is resting with the parties and not with the mediator. He is just acting as a communication channel between both of them. This is what is the concept. I hope you are clear with the difference between arbitration, mediation, conciliation, these three concepts. And if you have any doubts, you can write to us at iExamB. You can also stop this video and you can also download the PPT of this video and have more clarity on the point. Go through it. The concepts are very easy if understood in the right manner. Don't forget to subscribe and prepare 50% faster with iExamB. Thank you, everybody.